Today's presentation has been uploaded on the handout icon. So if you want the presentation, you can download it from the handout icon. Please feel free to write your questions on the comment section as you listen to the presentation, and the questions will be answered at the end of the session. Enroll on our free Learn IBIS Director e-learning program. This program is free of charge, and we encourage all CIPC um, applicants or SMMEs to register for this course and share this course with anyone that you feel might benefit from the session. Krista, you may start the presentation.
Good morning, everyone. Good morning, Shani and colleagues. Once again, our apologies for that technical difficulties. All was working, and then when we switched over, it closed down. So for those that do not know, I am Krista Kloko. I am the Senior Manager responsible for companies and closed corporations at the CIPC. And this relevant area, reinstatement, is one of the key areas that reports into the Companies and Closed Corporations Division. I am supported and accompanied by one of the team leaders in this area, Meshach Manuleke. He is standing in for his colleague, Sia. I know Sia last week did the presentation, but we couldn't go into the Q&A. All right, so let's jump into it. So the objective of this presentation or this webinar is, although reinstatement is fully automated from the front line, there is still a compliance aspect that you as the company and the intermediary or the representative of the company and CC needs to comply with. And as we have stated when we did the launch of the automation of the reinstatement process, is that even though it's fully automated, customers are required to keep certain documentation because we can at random ask for that supporting evidence to confirm that the legal requirements have been met by the company when they filed the reinstatement. So the objective of this webinar is to increase the awareness regarding this requirement, and also to state that we have started the process and we're trying to educate customers regarding how then to upload the evidence once the reinstatement process has been initiated. All right, let's quickly go through. So some of you that may have attended the previous webinar or the release webinar, you will know the objective of automation. But let's remind everybody just about it, that we're all on the same page. So automation is part of the CIPC strategy, and it provides for services on more efficient platforms. It's also to improve communications throughout the process. It's to reduce administrative errors and inquiries, to improve service turnaround times. And I'm sure all of you that have applied for a reinstatement is very happy that it's after payment, it is immediate. And then you just have to file your annual returns. So there's a marked improvement in the turnaround times. Better data collection and data control. It also allows for integration with other sources of data and to improve data quality. And of course, there is a download functionality for customers who have submitted to get access to your own documentation. All right, so the service was released on the 11th of August, and all company reinstatement applications are processed automatically. Manual submissions are no longer accepted, and any inquiries can be referred to inquiry reinstatements at cipc.co.za. Right, so what is the requirements for reinstatement? So the requirements, the legal requirements by practice note has not changed just because we have automated. The requirement that the company or CC must have had economic value or in business at the time of final deregistration is still applicable. Although we don't ask you when you file the reinstatement application, you are still required to keep that evidence and to make sure that the company meets those requirements upon the reinstatement. Also to be reminded, is a criminal offense to submit false information to the CIPC. Please note, we do take this seriously. We are in the process of laying a criminal case against the customer that forged a court order into one of our processes. So we do take action. Also note that upon the terms and conditions, when you access the service, you have agreed that the application meets those conditions. And in terms of law, if you have agreed that it's there, it is legally binding on you. So if you clicked agreed on the terms of conditions and those are not there, you have just lied to the CIPC intentionally. Therefore, it's very, 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 very important. Read the terms and conditions for the services that are available. Okay, again, this is just the terms and conditions that you had to comply with. You need to confirm that you've got a mandate. You need to confirm that the entity had economic value at the time of deregistration, and you have agreed to this. Just to confirm who may apply for reinstatement, I know for certain people this is tricky. So the first requirement must have been in business at the time of final deregistration or have economic value. Then who may apply? The Companies Act is quite specific. It says any interested person may apply to reinstate. Unfortunately, although a third party, let's say for example, I'm a creditor of company ABC. In terms of the Act, Section 82.4, I, as the creditor, can apply for reinstatement. But the problem lies within the regulations and other provisions of the Companies Act that states that the reinstatement process is only completed after the filing of the annual returns, the beneficial ownership, and the AFS-FAS. Now, as you will know, annual returns, you confirm information. So me as the creditor would not be able to confirm the annual return detail that is required or file the beneficial ownership declaration because I don't know that information or the financial information. And if I do submit it without a mandate, I basically again lie to the CIPC. So therefore, because of other provisions of the Companies Act, a third party, like a creditor, cannot apply for reinstatement via the application process. They unfortunately have to go to court in order to alleviate those requirements. Also very important, if you are a lawyer, if you go to court, make sure that the court order mandates the company to comply with its legal obligations within a given point in time. Failure of which, because they're still non-compliant and the non-compliance obligations has not been overridden, the system will pick up again the company for non-compliance. So that is who may apply and why. So let's quickly run through the steps. So step one, always before you transact with a CIPC, somebody is not muted in the background. Determine the status of the company. If you're on a reinstatement can only be filed if you're on AR final deregistration or involuntary deregistration. So always check the status. The status can be checked on BIS profile on the BIS portal. Secondly, assess whether there was economic value at the time of final deregistration. That's step 2. Step 3, source all the required documentation for the reinstatement, your evidence that it was in business or had economic value, your annual return information, your AFS, and your beneficial ownership information. By Colette, thank you so much. So once again, apologies for that. As I said, we tested all of this and it was working. I'm not going to go through the previous slides since the slides has already been uploaded. It's basically just, it's written content. So let's proceed with the steps for reinstatement. Determine the status. Assess whether there was economic value or that it was in business at the time of deregistration. Source all the documentation that you need for the reinstatement, the annual return, the AFS, the beneficial ownership. By sourcing that information beforehand, once the reinstatement has been processed, it makes it easier and quicker for you to complete those other steps to bring it to a full reinstatement. Once you've got all your documents, you submit your reinstatement application and you pay for it. That's step 5. You pay for it. Step 6. Um, Once you have paid for it under step 5, the status will change to reinstatement process, and thereafter you will be allowed to file the annual returns, beneficial ownership, and AFS and FAS. You've got 30 business days to do that. Once you have filed all the outstanding information, it will go back into business, and then you need to please ensure that all the contact details, all the address information, the financial year, and everything is updated post the filing of annual returns. Otherwise, what's going to happen? You're going to rinse and repeat the cause for why this was finally deregistered. The directors did not get notification, or there's something else outstanding. So those are the steps for reinstatement. I've marked step 2 and step 3 in red and in amber for the reason because it's very, very important that these steps are be complied with. They are critical. Right. Even after years of having this, under step 3, the type of documentation that is required when we request it, it's not necessary to upload it with the application. On a sample basis, we trigger a request for the evidence. These are just examples of what is regarded as sufficient proof: bank statements, immovable property, IP rights, shares, outstanding liabilities, lease agreement, assets, etc. Anything that shows that there's a current liability or an asset or some sort of reason that's relevant at the moment of final deregistration. Right, we have completed these. The importance of keeping your compliance evidence. So compliance ensures, the reason why we're doing this compliance check on a sample basis is to check that clients do comply with the requirements for reinstatement, namely that you were in business or had other economic value at the time of final deregistration. We didn't want to hamper the front end customer experience, and it also aligns to the CIPC objective that we do things on a sample or a risk basis to confirm that there was compliance with these procedures. The reason why we're doing this is we don't want to reinstate dormant entities because it poses a risk of abuse. All of you that may have attended the previous presentations on annual returns and deregistration remember, and especially with the grey listing, is dormant companies, bringing them back on the registry exposes people to fraudulent, possibly to fraudulent actions using that vehicles. Okay. So the purpose of this intervention of the compliance check is to improve the adherence, reduce the risks regarding dormant companies being reinstated, and to maintain trust within the regulatory environment. Also note that you don't want to do business with somebody that wasn't doing business. So therefore, there is value in it for yourself as a creditor or a service provider to make sure that you were in business at the time of final deregistration if you applied for reinstatement, because you want in reverse, also want when you do business with somebody that they were actually in business, that there's real value in it. So why do we require this? The reasons for this requirement, some of that has already been explained, is to ensure legal integrity. The proof that the business was in business prevents misuse of reinstatement for fraudulent or unethical purposes, maintaining the legal entity. It protects stakeholders. That's what I basically have said. So regulatory compliance and reinstated entities must fulfill filing obligations, maintaining transparency and accountability within the registry. It's not just, the registry requirements is not just to the benefit of yourself who applies for the process or the service, but for everybody within the economy. And remember, the CIPC registry is a national registry of businesses, and it reflects externally in terms of the global economic environment. And also complying promotes governance and trust within the registry and the business environment within South Africa. So associated risks Entities reinstated without proof can enable financial crimes, money laundering, tax evasion, harming corporate ecosystem. Reinstating entities without validation causes inaccurate records, eroding trust, and complicating the regulatory oversight process. False information reinstatements exposes third parties to disputes, litigation, and damage to business and regulatory reputation. Um, Reversing false reinstatement generates extra compliance actions. So if you filed without it and we find out, you're going to have a lot of admin in order to reverse all of these transactions and refunds, which put strains on CIPC resources. So you're going to impact somebody else that needs resources in order for them to assist with their matter. And of course, criminal exposure under the law. It's a criminal offense to lie to the CIPC because you impact on the global registry. So what is the current situation that we have on reinstatements? It's not yes, we've got a few challenges or troubleshooting items on the service because there's a payment module and there's updating of systems. Although we have automated, only entities with active business or economic value at deregistration are eligible, requiring evidence. And companies must file outstanding annual returns within 30 business days after reinstatements. So what's the current challenges that we are facing? So there's a few operational risks. Those that attended the webinar on deregistration yesterday may recall that I mentioned that as CIPC, we're migrating between databases. We are modernizing our infrastructure. So some of our information lies on an older database, while the newest services like reinstatements runs on a new one. So what's happening, because the two databases structures cannot be synced to be identical, that it sometimes happen that the data is not correctly synced. We call it synced or referred to the other database. And now we do have controls in place, but it will take usually, so if your data after your reinstatement or your filing of your annual return has not updated, give it 24 hours. Usually we run in the evenings, we're running protocols in order to sync the databases. So give it 24 hours if the status did not update, and then log an inquiry. If it still has not been updated, then we will go into it and correct it. So please give it 24 hours for the statuses to be updated for the services before logging any inquiries. Then on card payments, we are in the process also to add more card payments or EFT options. But because it runs also in a separate system, when you've done a payment and it says pending payment, just give the system 24 hours, again, to clear anything. If you still have a challenge, please log an inquiry. Then we'll notify our apps team and support colleagues to actually just clean that up. Unfortunately, again, it is as part of some of the challenges that we have with the migration between, or the modernization of our infrastructure. So please bear with us. We have got new projects coming online to improve that even further. All right, regarding reversal of status, regarding issues where the status gets reversed from reinstatement process to AR, before the expiration of the 30 business days, we similarly request that customers allow 24 hours. Before a few of the operational challenges on the front end component, we thought it is worth bringing to your attention that you know what to expect. Then what we have picked up, when we started the process of starting to trigger on the sample basis the proof for the evidence that the business was in business at the time of deregistration or had economic value, we picked up that there was a low rate of response. So the compliance assurance rate remains low, as many customers either ignore the request or is unsure what to do. And that's the other purpose of this webinar, so that we can create address that item as to say that it is part of the process. Also, there may be a lack of awareness, although we have mentioned that we will trigger these things on a sample basis. I think everybody was so focused on getting reinstatements automated on the front end that is where the key element was, because we had so many challenges within the reinstatement environment with the backlogs, missing applications, applications being rejected, and all those items. So we want to address behavioral challenges, and there's a need for targeted interventions. My apologies, I see, okay, we have done that. All right, so even when we trigger the compliance, the request to provide evidence that the business was in business or had economic value, the applicant to the filing of the reinstatement application will receive a notification that we are requesting that information. So there is an email going out. How you can comply is you can either go into eServices BIS portal or even the self-service terminals. You can go into there by either clicking on the link within the message, it will take you there, or you can go back to the application. Where you click on the OTP, there will be an options to upload your documents if your compliance assurance has been triggered. Please note that that option to upload documents will not appear when you submit the reinstatement application. That option to upload will only appear once we have triggered that specific transaction for the information. So you can either go onto the link or go back into the service and click on upload. And it's on all three of the major services. So what documents are required? We just need evidence that the business was in business or had economic value. That's the only thing we need. We know who the applicant was. The applicant has been shared via the customer registration process. So we basically only need that evidence. Again, that is step 3, to source all of your information and to make sure that that there was evidence to that effect. Right, so let's say you now got the email or the notification that your reinstatement transaction or application was triggered for assurance. If you do not comply, you risk withdrawal of the reinstatement and the status of the entity and going back into final deregistration. You are impacting the national business environment. Like we're saying, we're all trying to promote the business environment in South Africa. So you're basically exposing other businesses because you decrease the integrity of the CIPC registry. You have got the risk that we will take you a formal criminal offense with the police because you lied to the CIPC. So if you don't submit the proof, we assume that you've lied because why? On the terms and conditions, you agreed that there was evidence that the entity complies. So you've basically lied. Non-compliance disrupts operations and harms the reputation of CIPC, especially if we have to start reverting back your status. It's also going to impact your clients because all of a sudden you no longer exist. And we're also considering putting systematic blocks, meaning that you will probably be blocked from filing other applications unless you have got brought up all your evidence on the reinstatement process. So we are looking at all of these options, and we can trigger any of those options. So that brings me to the end. Hopefully you found this relevant as to why you need to keep your evidence, why you need to comply when we trigger your reinstatement application for evidence, and also clarified how to do it, and then what the possible impact may be on you or your client if you are an intermediary, if you do not comply with this. So that brings me to the end of this presentation. I hope you found this information useful and enlightening, and will now understand when we trigger your application as to what is required of you. Thank you so much. We will now go into Q&A. Alex, thank you so much for raising that. You said this is the third presentation that we were unprepared. We do apologize for the technical the technicalities. As I stated, we did prepare. We did test everything. It seems like the gremlins was out, so our sincere apologies for that. All right, Suzara, Johanna, your question relates to the fact as to can we link up the reinstatements to the declining balance? So I just want to refresh everybody about it. So as part of our modernization, we are migrating away from the declining balance, which means is that as soon as a new service is redeveloped or redefined or augmented, we then only make the payment option for card payments, and hopefully next year we will introduce electronic EFT. We cannot link it to the declining balance anymore. We did issue, Suzara, a notice about 2 years ago. If you go to notices, that clearly state that we are migrating away from it and the reasons why. What's currently happening, there is abuse of the declining balance system. Some customers are using it for tax evasion, so they make a big deposit into their account. Then at the end of the financial year, when everything is done, they ask for a refund, for example. We're also not a bank, so we're not allowed to keep that amount of deposits as well. So there's other reasons as well. So unfortunately, we cannot link any new service that we bring online or automate back to the declining balance. We need to migrate away from it. I hope that clarifies as to why it is only card payments. All right, Mbalene, you indicated that you tried to do a reinstatement, but you couldn't file the annual return. Unfortunately, you need to log that with the inquiry reinstatement team because we have to go look at it. There may be various reasons for it. As I said, there's a lot of services that are linked up to get to the annual return, so we need to see where it is. And the company's division is not responsible or doesn't administer financial statements or beneficial ownership, so we have to see where it is. Right, I see Meshach has already answered that. Teresa, we note your comment regarding the readability of the printouts, the white on white. Yes, we are in the process of changing our branding, so we are adapting. So for my future presentations, I will just note regarding the readability for it so we can improve it for you. Let me just make a note before I forget. Okay. All right. Right, then if you've got problems to log in, please remember you need to go to reset passwords or reset pass if you've got any reset issues. Yamna, I cannot answer your inquiries regarding beneficial ownership. It is outside of the scope of this presentation, but please liaise directly with the BO team with your inquiry. Okay, we see there's a similar question regarding the grey listing and beneficial ownership from Mbalenle. I hope I pronounced your name correctly. If the entity has been dormant for several years and is an AR final, what are the steps required to reinstate? Yamna, reinstatements are only if the business was in business at the time of deregistration or had any other economic value, including outstanding liabilities with SARS, have some credits due from it from SARS, has got properties. We do not reinstate dormant companies and CCs due to the risk that it has to the economic environment and the abuse of dormant businesses that can occur. Where can invoices be accessed for the payments made for reinstatements? That's the inquiry from Unadi. We do not issue invoices for these transactions. There is an option on our website in order to access your card transactions. You can access it from there. All right, Lerato, I note that you asked for a step-by-step guide and she's not allowed. I'm not sure what that is, but Lerato and colleagues, all step-by-step guides are published on the CIPC website. If you go to our main website at the bottom, we've got, I think, 4 green blocks. And one of those green blocks, there is a link for step-by-step guides. If you click on there, you'll have a full list of all the step-by-step guides that we have issued as the CIPC. Right. All right, then Rose is asking for a webinar on registration of external companies. Yes, we are planning to have another webinar on the automation of external companies, because a lot of us are on leave and we've got other priorities. We are probably going to schedule that for the end of January, beginning of February, but we will confirm at the beginning of January when that is. So we are planning for that. All right, we've already answered why the card payments. Can exceptions not be made considering that an SME was still waiting for a project? Unfortunately, no, Sydney. We need to be fair and consequential for all businesses. Also, remember, if you did not get the contract, you had no value. So if your company is finally deregistered, you can apply for a new company. In any case, if you are still busy trying to source business efforts, you should have complied when you've received the notices in any case. I know that people are trying to get used to those requirements, although it's been in there for over 20 years. It's been a requirement since I started my career in CIPC, and that is 20 years ago. So we can't make exceptions for SMMEs. You were supposed to keep your compliance up to date. It's a legal requirement, but you can register a new company because you don't have, that matter is not in place. All right. Okay. Good day, can you advise if we upload the economic value evidence during or after the reinstatement process? That comes from Tanya Boitumelu. You need to submit it afterwards when CIPC, the back office, have triggered your application for compliance assurance. So you don't upload when you submit the reinstatement application. It's only when we've triggered your transaction. And remember, we can randomly on a sample basis trigger these matters. All right. All right. So I think that brings us to the end of most of the questions. Dolores is asking if it's possible to show step by step. Unfortunately, it's a front end and the system is live, so we can't get real access. But we will check once Mr. Sekome is back. That's probably in January, to see whether we can get some, if we need to update the current step-by-step guide to provide more clarity on the upload of the supporting evidence. We will look at it for you. Can such outstanding issues be regarded as economic value to the entity? That comes from Udike. Oh, no, sorry, apologies. I think I've lost who that is. Oh, that's from Joshua. Can such outstanding issues be regarded as economic value to the entity? Yes, you just need to provide whatever evidence you have from SARS to say that there's an outstanding matter with SARS, enforcement engagement or outstanding liability, etc. Then you can also apply with reinstatement. So you just put in the relevant formal notification that you've received from SARS. All right. Colin is also asking again about the declining balance. As I said, unfortunately not. We are transitioning out of that. All right, then there's a lot of requests for the access to the presentation. If you have registered for the webinar, you will get it to the top. Otherwise, these webinars will be eventually published on our platforms, and then you can access it from there, especially our YouTube channel, CIPC at YouTube. You can access a lot of the content there as well. Lekau is asking, my company has been in final deregistration, cannot seem to intervene to start with the registration. Leka, that seems it's a little bit unclear. Please forward your inquiry to inquiry reinstatements, and then a team member will assist you from there. Just provide a little bit more clarity as to your inquiry.
Avika, there's a question from Anushka. What if a
All
client
right.
wants to reinstate the company for use in the future?
No, if you didn't use it, you lost it. So, Anushka, unfortunately, again, it's not about for future use. It is what is the value. Because remember, we're trying to keep the registry up to date as to who's actually doing business and should be on the registry. We don't want dormancy on the registry because it poses a risk. It waters down the integrity of the registry and the benefit that it has for other businesses to have up to date information. If they want to register in future, if they want to use it in future, the rule of thumb is you only register a corporate business, a corporate entity, a company, or a co-op if you have got an opportunity. So even if you're finally deregistered and your opportunity comes 2 years down the line, then you can go and register a new company. I hope that answers Anushka's question. Um, so I'm
Mohammed
just quickly
Ismail has
reading
a
here.
question here. My CC
I'm
company,
listening.
which was deregistered a long time ago, can I reinstate it again?
Can you repeat that quickly for me? Sorry.
My CC company, which was deregistered a long time ago, can I reinstate it again? It's from Mohammed Ismail.
Muhammad, again, the requirements. If you've got proof that the company or CC was in business at the time of final deregistration, 5, 10 years ago, you can still apply for reinstatement. Our law does not provide a limit as to when you come back in. Our law just requires the Companies Act place a mandate on the CIPC to make sure that we have got efficient and effective up-to-date registry of businesses. We do get it a lot of times whereby, especially with family businesses that gets inherited through the generations, a lot of the older business, especially if there's property, grandpa didn't tell grandson that there was a property. And then once somebody is trying to sell that property or realize it's there, that oops, the company was finally deregistered. So you can still apply, provided you've got the evidence at the time of final deregistration, whatever that may be. So, Mohammed, I hope that answers your inquiry. All right, so Marie is asking why all this information is not in a booklet. We are the back-end compliance assurance is a new component that we've brought in due to the automation to protect the registry and put control measures in place to protect it. So we don't create booklets for anything. We usually update our FAQs and our website content. That's also why we're doing these presentations, to create awareness. And what you have put on there is on the mandate that you have ticked when you submit your application. So you were fully aware if you read it. I'll just make a note that we consider updating the FAQs. Ria, I hope you found that is in order. As I said, we only recently started the compliance assurance, and we are working ourselves through it by creating all of these webinars, interventions, and to make it sure. All right. Shani, did you pick
Crystal?
up any questions that's still outstanding?
Yes, one more question from Cyblon and Lorato. They want to know if you can reinstate a company of a deceased director. Oh, I see that question is about 3 times, 4 times.
Okay. I'm going to bring you back to the law. If you're finally deregistered, whether it's for annual return non-compliance or voluntary, the legal entity does not exist. So meaning if you've got those statuses, as CIPC, we don't allow you to file anything relating to the company or CC except for a reinstatement. And once you're in the reinstatement process, then your annual returns, beneficial ownership, and your AFS. So what's going to happen? So on reinstatement, although we display that information, and you have to confirm who has consented to the reinstatement. Let's say, for example, Lerato and I are the members of the CC, but I have passed away. Now, Lerato is applying for reinstatement. So she will basically indicate herself applying for the reinstatement. I'm deceased. You can't really tick my consent, right? And then it will go through. And once everything is up to date, and remember that diagram with the different steps, step 8 is to update the registry post the filing of annual returns. So yes, you can reinstate a company for which a person, a director or a member is deceased, but you just need to bear in mind that you will have to update all of that information post annual return filing. We're also picking up a lot of businesses apply for reinstatement and never update the director's details, the addresses, post annual return. You're also going to land into trouble with that. Please update everything afterwards. But Lerato, so let's take the following scenario. I am the only member of the CC and I've passed away. Now my executor that's duly appointed by the Master of the High Court needs to finalize my affairs, which relates to the CC. So because we don't know who the executor is and we cannot upload the information, the executor, when he files for the reinstatement, will click, for example, myself, although I'm deceased. But because in law he's got a mandate to act on my stead, it is fine. Then he will file all the annual returns, do all the beneficial ownership and everything after that. And once it's back in business, he will have to update the registry. He will have to update the membership to reflect him as the executor, as nominee officio of the CC. So again, yes, decease can be done, but everything needs to be updated post reinstatement and filing of annual returns. Please never forget to update the registry past the annual returns. Again, if you don't update, you sort of wash and repeat the issues that you have that related to deregistration again. Also, you may sit with liabilities, and if you don't update an accreditor believes, but you intentionally, you can be held criminally liable by that person with whom this business is doing business because you didn't comply with the law. So, Lerato, I hope that clarifies that question. Shani, anything else?
The second last question that we have from Christian, our favorite attendee. A CC was converted to PTY, but but the CC profile AR is still racking up. Should I do anything on the CC profile to stop it racking up AR as the AR are being paid on the PTY side?
Okay, so if it's converted, I suspect what's happening here, when an entity is converted, we assign a status of converted. Is it status 20? I can't now remember what it is. And therefore, it should not be picked up. Because legally, once it's converted, it doesn't exist as that legal entity. So, Christian, please, if you've got an example that it allows on the front end, please notify the reinstatement team on the inquiry side that we can just go back and assess the annual return application, that it runs according to its specifications. Thank you, Christian, for raising that. But we need the example, unfortunately, in order to look more onto it. But you keep filing on the PTY side, not the CC, because it does not exist.
Okay. I don't see any other questions. If we have missed any questions, they are welcome to email us with them. Remarks that you would like to make, Krista, before I end the session?
All right. Yes. Thank you so much. Once again, for really taking sorry, I've got a bit of a flu going on with all this wet weather that we've been having in Gauteng. It's a wonder that I didn't wash away with the storms. So thank you very much for availing yourselves and making the time in order to attend this webinar and in order to understand the reinstatement process better, what is expected, and how does it work post the reinstatement on us assuring that we've got an up-to-date and a business registry within South Africa that has got integrity and value by providing your evidence once we request it, and also to understand that once everything is done, you have got a duty to update all the information regarding directors, as Lorata saying, the executive, the person is deceased, to update the registry with the latest information post annual returns. But once again, thank you very much. And once again, our apologies for the technical difficulties. We will also go back and see what happened so that we can improve how we do this. Thank you so much.
Thank you, Advocate. On behalf of this brings us to the end of our session. On behalf of our entire team, thank you for attending today's webinar. I hope you found the presentation valuable, and apologies for the technical glitch that we have. Until next time, stay safe and take care. Goodbye.